Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage.
Today, we break down the February 25th, 2026 opinion in Villarreal versus Texas. And this one touches something fundamental. Once you take the witness stand, can a judge tell your lawyer what he's allowed to say to you overnight?
The short answer the court gave, some, but not much. And the line the court drew, that's where things get interesting.
We previewed this case and covered oral arguments. Check those episodes out if you want the full backstory. Today, we focus on what the court actually decided.
The Supreme Court ruled 9-0 that trial judges may order defense attorneys not to coach a defendant's ongoing testimony during an overnight recess without violating the Sixth Amendment.
The case asked whether the constitutional line separating two prior decisions, Geders and Perry, runs on time or subject matter. Justice Jackson's majority held that once a defendant takes the stand, testimony coaching loses constitutional protection, while everything else, strategy, plea negotiations, witness decisions, retains full Sixth Amendment protection. Trial judges now hold a clear tool to preserve truth-seeking at trial without dismantling the attorney-client relationship. Today, we walk through the majority, Justice Alito's concurrence, and Justice Thomas's concurrence in judgment. Then break down where the justices split and what this decision means for defendants, defense attorneys, and trial courts nationwide.
Before we go further, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, let's get into it.
So, set the scene. David Villareal sits on the witness stand in a Texas murder trial. He's the only defense witness. His story, self-defense. The victim tried to choke him to death. He grabbed a knife.
High-stakes testimony?
The highest. And mid-direct examination, meaning his own lawyer hasn't even finished questioning him yet. The judge stops everything, scheduling conflict. Trial recesses for 24 hours.
And that's when the judge does something that ends up at the Supreme Court.
Right. Before everyone goes home, the judge turns to defense counsel and says, "Before you talk to your client tonight, ask yourselves whether the topic would manage his testimony in front of the jury. If yes, that conversation doesn't happen."
But everything else, strategy, sentencing, plea discussions, all still on the table.
Exactly. The judge told Villareal directly, "I'm not telling you, you can't talk to your attorneys. Just don't coach the testimony."
Defense counsel objected. Villarreal came back the next day, finished testifying, and the jury convicted him of murder, 60-year sentence.
And Villareal spent years arguing that order violated his Sixth Amendment right to counsel.
The Supreme Court disagreed 9-0 on the result, 7-2 on the reasoning.
Now, here's the legal puzzle at the center of this case. The Supreme Court had two prior decisions that seemed to pull in opposite directions, and lower courts spent decades confused about where the line actually sat.
Walk me through them.
First case, Geders versus United States, 1976. A judge told a testifying defendant, "You cannot talk to your lawyer at all during the overnight recess, complete blackout." The Supreme Court struck that down. Said overnight recesses cover way more than testimony. Strategy, tactics, evaluating the day's events, even plea negotiations. A total ban goes too far.
Okay, so overnight recesses get protection.
Then 13 years later, Perry versus Leak, 1989, different judge, different recess. This time, a 15-minute daytime break. Judge says same thing, no talking to your lawyer. Supreme Court upholds it. Says during a short pause, virtually any conversation will focus on ongoing testimony anyway, and defendants hold no constitutional right to discuss ongoing testimony with their lawyers.
So brief recesses, judges can shut it down completely. Overnight recesses, they can't. That sounds like a time-based rule.
That's exactly what Villareal argued. And the Supreme Court said, no, you're reading those cases wrong.
How so?
Justice Jackson's majority said both Geders and Perry actually rest on content-based premises, not time-based ones. Geders protected overnight consultation because defendants have matters other than testimony to discuss overnight. Perry permitted a total daytime ban because during a short pause, practically speaking, virtually any conversation will concern testimony only. Time predicted content in each case, Content drove the constitutional result.
So the real question was never how long the recess lasted.
Never. The real question, what subject matter does the Sixth Amendment protect during a mid-testimony break? And the court's answer. Once a defendant takes the stand, discussion of testimony for its own sake sheds its constitutional protection. Everything else retains full protection, overnight or not.
Define for its own sake.
Coaching it, adjusting it, debriefing it midstream. Anything aimed at shaping what the defendant says next based on what he already said. That category, unprotected.
And what stays protected?
Trial strategy, witness availability, plea negotiations, sentencing discussions, factual information the lawyer needs to make tactical decisions. Even, and this matters, discussion of why a defendant should consider a guilty plea, including how the ongoing testimony affects the trial's prospects.
Wait, so counsel can tell a client, you should think about a plea because your testimony today hurt you. Considering.
Right up to a point. You can say, we should consider a deal because this trial looks rough. You cannot say, we need a deal unless you clean up the 3 mistakes you made on the stand today. The first, protected strategic advice. The second, testimony management. Same conversation, different constitutional universe.
That's a fine line.
It really is. And Justice Jackson, seemingly trying to throw defense attorneys a bone here, because they argued at oral argument that nobody can reliably distinguish testimony management from incidental testimony discussion, actually walked through concrete examples in the opinion to show how the line operates in practice.
What did she say?
She gave 3 clear examples of discussions that stay fully protected even overnight. 1. A lawyer asks the client about a new potential witness the prosecution mentioned for the first time during the defendant's testimony that day. Protected. 2. A lawyer asks about a new piece of evidence that surfaced during testimony. Protected. 3. A defendant asks his lawyer whether his answers complied with the court's evidentiary rulings. Protected.
So anything where the testimony is the starting point for a broader strategic conversation
Stays protected. What loses protection? Discussions where the testimony itself is the destination. Adjusting it, tightening it, smoothing over rough patches, recalibrating the narrative based on how the direct examination played out, that category. Gone the moment the defendant takes the stand.
So how did the court apply all of this to Villarreal's actual situation?
Straightforwardly, the judge's order prohibited counsel from managing Villareal's ongoing testimony. That targeted the unprotected category, and only the unprotected category. Strategy untouched, plea discussions untouched, sentencing untouched, factual consultation untouched.
And critically, neither Villareal nor his lawyers ever said the order blocked any conversation they actually wanted to have.
Not once. The record shows 0 reported impediment, order upheld, conviction affirmed.
Now let's talk about the fault lines within the court, because this wasn't a clean 9-0 across the board.
Right. 7 justices joined Justice Jackson's majority opinion. Justice Alito concurred separately, and Justice Thomas, joined by Justice Gorsuch, agreed the order survived but refused to join the majority's reasoning. Start with Alito. He joined the majority, but still felt the need to write separately. Why?
Justice Alito wrote separately to make sure that line stayed sharp. He grounded the whole analysis in a baseline principle. When a defendant testifies without any interruption, the jury hears his story in his own words. No notes passed from counsel, no earpieces, no real-time coaching. A recess shouldn't blow up that baseline. Indirect attempts to shape testimony carry the same constitutional infirmity as direct ones. Alito wanted to anchor the entire framework in a baseline principle that he felt the majority left implicit. His starting point: when a defendant testifies without any interruption, the jury hears his story in his own words. No notes passed from counsel, no earpieces, no real-time coaching. A recess shouldn't blow up that baseline.
So his concurrence wasn't so much of a disagreement, but a sharpening.
Exactly. And he sharpened it through a concrete hypothetical. Counsel may tell a client overnight, we should consider a plea because this trial looks rough. That protected strategic advice. Counsel may not say, we need a plea unless you clean up the 3 mistakes you made on the stand today, or unless you stop scowling when you return to the stand tomorrow. Same conversation, different constitutional universe.
Because the second version uses strategy as a wrapper around testimony coaching.
That's precisely Alito's point. Indirect attempts to shape testimony carry the same constitutional infirmity as direct ones. Dress it up in strategic language all you want. If the core purpose is adjusting what the defendant says next, based on what he already said, the Sixth Amendment doesn't protect it. Alito wanted that principle stated clearly, so lower courts couldn't exploit any ambiguity the majority left open. Let's move to Thomas's opinion. Thomas had real problems with what the majority wrote.
3 of them. First, he said the majority announced a brand new rule that finds zero support in Perry. The majority said defendants retain a constitutional right to discuss testimony incidentally in service of other protected topics. Thomas pointed out that Perry stated in plain terms that defendants hold no constitutional right to discuss testimony while it remains in process. Full stop. Perry even endorsed orders categorically forbidding such discussion. The majority created a carve-out Perry never recognized.
So Thomas read Perry as drawing a harder line than the majority did.
Much harder. Second problem, Thomas argued the majority ventured into hypotheticals this case never presented. The order at issue passed constitutional muster under any reading of existing precedent. The majority had no business identifying new circumstances, facts not before the court, in which testimony-related discussions might retain protection. That's the kind of advisory opinion the court isn't supposed to issue.
And the third problem?
Methodology. The majority framed any conflict between the Sixth Amendment and untutored testimony as resolving in favor of the right to counsel. Thomas rejected that framing entirely. Perry said when defendants become witnesses, witness rules generally apply to them. The majority placed a thumb on the constitutional scale that Perry specifically declined to place, and did so without anchoring the move in the Sixth Amendment's original meaning.
So Thomas would have written one paragraph, affirmed, and gone home.
Essentially, he saw a straightforward application of existing precedent. The majority saw an opportunity to clarify doctrine. Thomas called that needless expansion. The majority called it necessary guidance for lower courts that spent decades confused.
Now let's spin things forward. What does this decision actually mean going forward?
A few things. First, it resolves a genuine circuit split. Courts of appeals around the country diverged on whether any overnight testimony discussion restriction could survive the Sixth Amendment. Some struck down all such orders, others upheld them. The court drew a clear line. Targeted restrictions on testimony management, constitutional. Blanket bans sweeping in protected discussions, not.
So a judge can restrict. A judge cannot eliminate.
Right. And the order has to target testimony management specifically. A court cannot tell defense counsel, don't talk about the case at all. Cannot say, don't mention anything that came up today. Can say, don't coach the testimony.
What about the defendant who claims the order chilled protected discussions even if it didn't technically prohibit them? That was Villareal's backup argument.
The court rejected it. Villareal wanted a prophylactic rule, no overnight restrictions at all, to bubble wrap protected discussions from any chilling effect. The majority said no. Lawyers understand the distinction between coaching testimony and discussing strategy. They know how to navigate that line. An order prohibiting testimony management only does not present the overbreadth concern that drove courts to strike down blanket bans.
Bottom line this for me.
If you take the witness stand in your own defense, you accept certain burdens that come with being a witness. One of them, your lawyer cannot spend the overnight recess polishing your testimony. Everything else about your defense, strategy, witnesses, plea options, factual decisions, your lawyer can advise you fully. The Sixth Amendment guarantees the assistance of counsel. It does not guarantee the coaching of witnesses.
That's Villarreal versus Texas. 9-0 on the result, 7-2 on the reasoning. Justice Jackson writing for the majority, Justice Alito concurring, Justice Thomas concurring in judgment only, joined by Justice Gorsuch.
A clean win for Texas. A new constitutional framework for mid-testimony conferral orders nationwide. And a sharp reminder from Justice Thomas that the court should decide cases, not draft treatises.
Thanks for listening to today's High Court Report episode. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. Questions about this case? Reach out via LinkedIn or email at scotus.cases.pod@gmail.com. Talk to you soon.